can't curtail and limit, since it's not one of the rights that have been provided for under Article 25. And then we are praying that when you retire, that you look at the principles that the court highlighted in these two authorities to grant the prayers that we have offered and prayed. That is all.
Yes. I'll just have a bit to address, then I'll invite my learned friends to address you on some few aspects. I will address you on the aspect of the pre-arraignment detention in respect of the first accused person, to which the prosecution is guilty of, and further guilty of the duty of non-disclosure. The first accused person was arrested on the 18th arrested on the 18th at 0900 hours, that is 9 p.m. at JKIA when he was en route from Mombasa. 18th of July at 9 p.m. or thereabouts. He was then taken to, driven all the way to Kirinyaga County and detained at a police station called Wanguru Police Station. While there, Your Honor, he was denied his rights to make any contact to either his family members or his advocates. He spent the whole day there yesterday. Never ever even informed of the reason for the arrest. I am addressing a violation of Article 49 as I address you. He was denied right to access to counsel. And most fundamentally, he was denied the right to be produced before a court of law within 24 hours. This is a time at around 5 o'clock, that 5 o'clock on the 20th of July, that the accused person has been able to see a judicial officer or to appear before a judicial officer. There is no explanation that has been adduced why all that transgression had to take place. And it's always the duty of a trial court it's always the duty of the trial court to inquire on that particular aspect. As and when the same is brought to the attention of the court. You know, pre-arraignment detentions were outlawed, and Article 51 speaks to that fact. And the case in the court, the High Court, in the case of Musa Bwagwa versus Mwanasi and 9 others, for the Chief of Kenya Defense Force, EKLR.
The case of
Musa Mwabwaga, that is MBWAGWA Mwanasi and 9 others, versus the Chief of the Kenya Defense Force and others, 2021 EKLR. That aspect of pre-arraignment detention was addressed. And the High Court said it was unconstitutional. And therefore, a charge that is premised on a violation of the Constitution, the court ought to interrogate the integrity of that charge and the propriety of that charge. Even in the affidavit that they have brought before you, they have not addressed that aspect. As I pen off, the court is called upon by Article 3 to defend this Constitution. Article 10 enjoins the court to uphold the Bill of Rights and the rule of law and a just society. Article 27 enjoins the courts to ensure, Article 27 enjoins the court to ensure that there is equal protection of the law, equal enjoyment of the law, and equal benefit, and outlaws any form of discrimination. We need an answer. Why was Honorable Babu Owino not brought before court within the prescribed period? Number 2, whether a charge that is premised, I'm penning off. Oh, sorry, Your Honor. The answer that we are seeking is why he was not brought before the court as decreed by Article 49, clause 2F. Number 2, whether a charge that is premised on a violation of the Constitution has legal propriety, and whether the same can be the premises for denial of bail or bond. Mr. Okati will address you.
Yes, Your Honor, I will start by indicating, Your Honor, that it is true that actually not only the first accused persons, but all the accused persons are being arraigned before you, Your Honor, outside the mandatory 24-hour limit. Your Honor, the 5th and 7th accused persons were arrested on Monday the 17th day of this month, 2023. So that we are just shy of the 5 working day period, with the 6th and 2nd accused persons being arrested on the 18th alongside the 1st accused person. Your Honor, we will not belabor this fact because we will pursue it at the High Court in terms of the violations, Your Honor. But that is important because it tells you a lot as to why we are even addressing you at this time, Your Honor. Your Honor, what has happened, and in a nutshell, there is a skit that has been written and, Your Honor, the duty of the investigators and with a lot of respect to the battalion of prosecutors, senior prosecutors, is just to ensure that these accused persons fit that skit. Your Honor, there is no iota of evidence that has been placed before you either through their affidavit, Your Honor, or the oral arguments that suggest that there is any compelling reason, Your Honor. None whatsoever. Your Honor, if you look at what they have attempted to indicate as compelling reasons, Your Honor, and that is from paragraph 7 to paragraph 12, Your Honor, you will see there's a repeated use of the word reasonably believed. Reasonably believed. But you're not being told, Your Honor, reasonably believed by who? To sustain this particular very heavy averment. Who is this who is reasonably believing, and on what basis? You do not have that. Your Honor, in fact, maybe this may not go on record, but this is the first affidavit I've seen from, HSC Victor Juma Witi that has no annexure at all. The very first one, I've never seen. And that tells you there's nothing. Witi can never do such an affidavit. There's nothing.
You're not clarity of records. It's done by the investigating officer.
I check that. It is okay, Your Honor, but you read it for yourself, and I do agree we cannot do that. However, Your Honor, you will notice that even on the substance of the charge, Your Honor.
He has a similar.
Yes?
He has a similar.
It is my learning. But he has clarified, so I'll leave that point.
Okay.
But Your Honor, if you look at even the charge itself, to show you how they have actually stretched to the point of breaking a back, that is what the prosecution has done. Your Honor, they are telling you in very good English that these events happened on the 7th and on the 18th day of July. 18th, 2 days.
On which days?
On the 7th day of July and the 18th day of July. That is on the particulars of the offense. And Your Honor, they are telling you further that these events happened at Kamukunji. Your Honor, they have, and this is common knowledge to them, they have admitted that Babu was, the first accused was arrested at JKIA. On the same 18th, at around 10, because he landed at 25 hours. So, Your Honor, the question is, do we have two Babu Owinos? Does he have a clone that was at Kamukunji that day? Your Honor, it's able for the court's eyes, the ticket that says clearly he was landing at 21:25. Your Honor, if you look at further to demonstrate the fact that there is no compelling evidence, and indeed, even the substance of the charge is something that the court ought to look at in admitting the accused persons to bond. Your Honor, I'll refer you to paragraph 7.
Yes, sir.
Your Honor, they are telling you, and my learned friend Mr. Ringo has told you that there are people who have been rioting or who have been picketing, especially where the first accused person represents that constituency. So that is the compelling reason you are being told. Your Honor, there is a decision or a ruling by your brother, and that is the Honorable Justice Mogambi. Your Honor, that is in the case, if I may, in the case of Edwin Sishana Amboso versus LSK and 4 others. We have provided that to yourself and to the prosecution. That is HCC petition 255 of 2023. Edwin Sishana Amboso. Your Honor, it says in order 2 and 3, and I want to wind up at that point, that it is the responsibility of persons who have announced and organized the said demonstrations to provide guidance and leadership to the participants. Your Honor, the first accused person is not even a principal in the Azimio coalition. He wishes he would have been. He is not. And there is no evidence that has been given that he organized any of these protests. Which in any case, Your Honor, remains legal.
Yes, sir.
It remains legal because your brother declined to injunct the said expression under Article 37. Your Honor, Order 3 is also very important. It says acts of violence and destruction are personal, and the relevant authorities must deal with individuals. Acts of violence or destruction of property are personal crimes. So it cannot be a crime where vicarious liability, like the prosecution is trying to adduce. Your Honor, the charge that has been preferred, Your Honor, the history of this charge is very important, and I think this court will bring this matter to a rest. Your Honor, the Section 77(1) of the Penal Code, Your Honor, was brought into our laws, Your Honor, in 1960 as an amendment. So that it didn't originate from the Britons. It's something that was brought here by the Britons themselves. It wasn't in their own laws. And the purpose of that, Your Honor, was to ensure that this country does not get independence. It was to deal with the Mau Mau freedom fighters. That was the purpose of this particular section that the DPP is actually telling us to use today. It was to suppress. So that is what this court is faced with in terms of this charge, Your Honor. It is to take us back to those days and those people who never wished this country to get independence. That's exactly the essence of this charge. And Your Honor, you will not find even authorities. I think people have been shy to use this section. You will not find authorities in terms of these sections. Courts have been shy, prosecutors have been shy. But today, we are the day where it can be brought in broad daylight. We will deal with it, Your Honor, at a different forum. As I finish, Your Honor, I would want to... Your Honor, I will heavily beg you, and that's why I'm trying to limit these submissions, Your Honor, to know that the first accused person, and I believe even the rest, but for him, he has not eaten, Your Honor, for 3 days. Not eaten, not taken water. 3 days. And because of where he was incommunicado. 3 days, Your Honor. Even Mackenzie was fasting, was eating. Yes, Your Honor, so we really beg. This court is to be used to extend that inhumanity. That is what they are trying to do. And we beg this court, with the powers given to you by the Constitution and the people of Kenya, to give us the chance, Your Honor, to enjoy that. He's not at a flight risk. He's an honorable member of parliament, as indicated by Ryungu. Those are the words he's used, honorable member. And the rest are equally Kenyans. They will come to court. You can put conditions, Your Honor. They will abide by all that. They are willing to abide by all that. Your Honor, lastly, the first accused, Your Honor, is not well. He's actually not well, and I will not take a lot of time. He's been denied access to medicine, which he was taking, and I'm so sure he needs to go to hospital after this. So we'll be begging also that is considered, Your Honor. He has a special physician who sees him at Nairobi Hospital. That is all, Your Honor. Maybe my sister, just for gender balance, if you give her just 1 minute, we are trying to...
Thank you very much, Your Honor. There is a maxim.
Sorry, just a moment. Mr. Katz,
Yes.
you are saying that somebody has not taken water for 3 days.
Yes.
He has not taken water for 3 days.
How
In fact,
how did you know?
yes?
How did you know?
Pardon?
Sorry, how did you know?
I've actually, we went to Uhuru police station in the morning. We were there even yesterday. We were dispersed. Even advocates couldn't access. But today I've been with him at the basement cells. That's the first time we've been able even to access him. That's how inhuman this has been. He has not taken his ear and talk, and I've confirmed that from him. And I believe.
So you just a moment. Did you give him water yourself?
Your Honor, the conditions down there, and I really empathize with the officers here. There are strict instructions. Even for us to gain access, it wasn't that easy. I even tried to call my colleague. Ryung is very good at helping us in those issues. But
Your Honor, we attempted to carry water from the gate. We could not be allowed to come in. I'm sorry. We could not be allowed by the police officers to come in with anything.
Okay. I just wanted to find out why he's talking about it here.
What Mr. Okati is not telling you is Babu Owino has been shakaholad for the last 3 days.
No, but there was also a tweet that the Jiro said that the police officers treated them very well. So I'm wondering what measure of treatment is it? Do we know 1 minute here he's saying they're not treated, but he tweeted and said the officers were very professional and treated.
Your Honor, I'll deal. No police officers are my plan. I'll deal. I'll defend.
Thank you very much, Your Honor, for your protection and guidance. The 2010 Constitution that was passed in this country is one of the best documents we have in the country. The act by the prosecution is actually to more of mutilate than safeguard, and we ask this honorable court to safeguard the interests, especially of the accused persons, in line with Article 49 and also Article 50, which gives the right to fair hearing. There is a maxim that says, "He who comes to equity." Sorry.
He who comes to equity
Must come with clean hands. And I wish to submit that the prosecution has not proved that they are coming with clean hands. From the time the first accused person was arrested to the time he has been presented to court, he was denied the right to representation. He was denied access to the basic fundamental rights accorded to each Kenyan. The prosecution, in their own domain, have judged the accused persons and decided to be the judge and the jury. Your Honor, the accused persons, like you've been told by my colleagues, have not been able to eat. Their whereabouts, especially for the first accused persons, was not clear, even to his legal representation. We have been to different police stations from the time he was arrested. And the key question to the prosecution thus is, an accused person has rights safeguarded in this constitution. Why was the Honorable Babu Owino kept away from his legal team as enshrined in the Constitution? Why was the family not made aware of his whereabouts? And why was he not arraigned in court as per the Article 49F, which talks clearly of the procedures on how to deal with an accused person? Therefore, it is my humble submission that
Just a moment.
the prosecution have not proven to come with clean hands, like I said. It took them from the time they arrested the accused person to today at 5:20 to come up with this affidavit that is full of assumptions, innuendos, and presumptions. If you look at the affidavit,
Your Honor, just for guidance, I don't like interjection. You had directed and indicated that it should have been done by 6, so the prosecution ended up being curtailed. So we just need direction whether there's a leeway just to continue with the time.
She's winding now.
As she said, equity still comes with equity.
equity must come with clean hands.
So even as we require equity on
Yes. Bashir, everything that is being said is going on record, so you will not need to repeat
Yes,
what another council has already said.
much obliged, Your Honor. So, in parting shot, my humble submission to this honorable court is that the accused persons are not at flight risk, and that the affidavit presented before this honorable court does not prove or necessitate reasons why they should be denied bail, and therefore I request this honorable court to protect, uphold, and safeguard the 2010 Constitution. Thank you, Your Honor. I would like to call my senior, Awele, to wind up.
Yes, ma'am.
Yes, Your Honor. Thank you so much. I will not take too much of your time, Your Honor. I appreciate that you have spent so much of your time already for the day, except that what is before you, Your Honor, is a very fundamental issue that goes to the heart of rights that are guaranteed and protected under the Constitution of Kenya and under the Bill of Rights, no less. That bill, Your Honor will appreciate, is not just an ordinary chapter in the Constitution. It essentially is the heart of this Constitution. You violate any of the provisions of that chapter, you essentially snuff out the life of this Constitution for all we know it to be. And I say that, Your Honor, with great respect, because as a practitioner, as an officer of this court, which I believe Your Honor has been before ascending to this very hallowed position in the judiciary, we have a duty, Your Honor, to enforce and uphold and defend this Constitution. And in the course of doing so, particularly with the division of labor within our courts of law, as you deal with these questions every other day, Your Honor, sometimes the detail of it and the weight and significance of some of the provisions of this Constitution may be lost. And most of the time, inadvertently. And I say that, Your Honor, because it is now becoming a norm that that have been created under this very Constitution and under the terms and conditions enshrined in this Constitution are now repeatedly and so brazenly violating cardinal rules. They are repeatedly, Your Honor, and so brazenly violating cardinal provisions of this Constitution that we as a people agreed will determine the relationship between those whom or to whom we delegate authority to exercise on our behalf and us or we the people, and between those agencies inter se. They are violating the common bond. And that is very critical and important, Your Honor. It is critical because, as I started my submission, this Constitution is the lifeline of the existence of this country as a nation state. You snuff life out of this Constitution and you invite chaos and anarchy in the manner in which we coexist. And so, the violation of this Constitution, particularly by those to whom we delegate authority, cannot, and my Lord, cannot, this must be taken very seriously, cannot be taken lightly. And that is why I said, as I started, Your Honor, and I said it with utmost humility, that in the course of our ordinary practice, particularly before these specialized divisions of the court, it is very easy to lose the detail, the weight, the significance, the nuances, the detail, the significance, the nuances of some of the provisions of this Constitution as we intended them to operate. So that, Your Honor, it has now become a very sickening trend that police officers, despite express mandatory provisions of this Constitution that proscribe the holding of detainees for more than 24 hours without compelling reasons, will very comfortably appear before you hours after they have violated a mandatory provisions of the Constitution and present an accused person before you, and then without batting an eyelid ask you for permission to hold them for even a longer period of time. Your brother, the Chief Justice Emeritus William Mutunga, coined it very interestingly. The utadu attitude. That an agency created under this Constitution, exercising powers under this Constitution, presumed to be aware of the proscriptions and the prescriptions of this Constitution, can violate it and then come before you and ask you to perpetuate that violation by granting them more time to hold accused persons for an even longer period of time. Your Honor, before you are just these two documents. Your Honor, there's a charge sheet. And there's an application to hold these accused persons for a further period of time, and specified time for that matter. You can see the mischief. They're even asking you to just grant indefinite leave for them to hold these accused persons for an indefinite period of time. And Your Honor, just scan through these documents. Not a single explanation has been attempted for why these gentlemen are being brought before you more than 24 hours after they were arrested. The Inspector General of Police has not bothered to provide the Director of Public Prosecution. With any reasonable explanation, or any explanation for that matter, why these gentlemen were held for that long, and the Director of Public Prosecutions, who under this Constitution is supposed to exercise
Just a moment. How many more minutes?
Your Honor, can I take just 10 more, please? Well, Your Honor, at the heart of these submissions before you is a freedom of gentlemen here who have been held incommunicado for more than 24 hours. I think they deserve just that extra 10 minutes. Your Honor, the Director of Public Prosecutions, an office created under this Constitution, who is supposed to exercise independent oversight, as a countervailing measure deliberately created by this Constitution, has approved a charge sheet most obliged. Yes, has approved a charge sheet, Your Honor, which does not, in fact, has not only approved a charge sheet, has actually caused to be drawn an application to detain the accused persons and therefore perpetuates violations against the Constitution without even bothering to inquire from the Inspector General of Police on whose behalf these accused persons were arrested. Why have you been holding them incommunicado for more than 24 hours? And that points to another lapse in the respectful and enforcement of the Constitution of Kenya, which I have in my remarks earlier said pose grave danger to our continued existence as a rule of law country. What does the DPP do instead? They also brazenly even attempt to fill the gaps for the DCI or the IG by even attempting to adduce evidence from the bar. Evidence that is not even in the affidavit of the corporal who purportedly has the knowledge of first-hand information for why this accused person should be held any longer than is necessary. Where does that leave the policy or constitutional objective for why the DPP was created as an independent office to check the Inspector General of Police in the discharge of his mandate? A danger. That is a danger. To the common bond that I alluded to, that this court must guard against. And my Lord, all that I have said summarize into this very simple submission. We are before you seeking reasonable bail terms for this gentleman, the accused persons. Your Honor, does the conduct of the IG, does the conduct of the DPP count for something as you consider my learned friend, Ms. Asha Bashir, has submitted to you that he who comes to equity must come with clean hands? The conduct of the DCI, the conduct of the DPP that I have outlined in very brief terms before you, does that, Your Honor, count for something? Does it hold any weight in your decision or in your consideration of the application pending before you for the detention of these accused persons for a day longer? It surely must. The misconduct that I have alluded to is not just any misconduct. They are violations of the Constitution. Article 2 is very clear in that regard. Any violation of the Constitution, they may not have any fatal effect to the charges before you, but it surely must have some effect and weight on your discretionary powers in considering an application for bail and for bond. That said, Your Honor, the law on bail and bond applications is fairly well settled, and I will not rehash that law or the principles that are applicable, save to invite you, Your Honor, to always bear in mind the policy guidelines by the NCAJ on bail and bond of 2015, and in particular, the purpose or utility of bail in a criminal prosecution such as this. That utility, again, Your Honor, is fairly straightforward, and I will not rehash it. I just want to emphasize on one point, and that is the burden of the prosecution in demonstrating compelling reasons why an accused person should not be denied bail or bond. Again, it is fairly well settled, Your Honor, that that burden reposes in the prosecution. It only shifts Only shifts to the accused persons where compelling prima facie reasons are demonstrated to your satisfaction. Your Honor, compelling reasons are questions of law and fact, and therefore can only be presented to you either by evidence or by reference to specific provisions of the law to justify the application of the order sought. Allow me to concentrate on just these two documents.
Just a moment.
Most obliged, Your Honor.
I have tried to limit time so that we do not sit at night. Hours of darkness begin at 6:30. It's now 6:40.
You know, we start here up to 4 in the morning.
Let me finish.
Oh.
So we are going to stop at this point. Whatever submissions that are remaining, because we will not finish today. Because we are at Mr. Welle, this side.
We donate our time to the other, Mr. Omar.
I'll deal with all the others and the president.
And then now Mr. Riul and his team have to respond.
You know, we can take 7 minutes in response.
Let me finish.
Yes, Your Honor, also
Sorry,
here for the 6th and 7th, I donate the time to my seniors.
So it is getting dark and we have a crowd inside the building. I know you don't work here. But there's a danger in keeping this large number of people within the court premises at night. I have tried to control Mr. Welle, that is going on and on, so we
Your
cannot
Honor,
stop him fire.
I would not want to be the one to hold this gentleman here for you, Your Honor. I am happy to take your directions on how you wish to use my time.
What I would prefer is that if you are likely to take
I'll take the time you mentioned.
another period of more than 5 minutes, then it is better we stop at this point and we continue tomorrow.
No, I'll conclude. I'll conclude. Within those 5 minutes, I'll conclude.
You are sure you have covered all the areas you wanted to cover?
Your Honor, in the interest of the accused who have been held for so long, I will do less than 5. I'll limit myself. If it gets to 5, just cut it out. Yes, I will take less than. Yes. Let me just conclude the point that I was trying to make. So, Your Honor, the compelling reasons that the DPP provides can only be gleaned from these two documents before you. Very briefly, Your Honor, please refer to the charge sheet as against the application before you. Review that charge sheet. The offense that the accused persons have been charged with against the offenses for which the prosecution now seeks to hold them are diametrically different. You have been told, Your Honor, that the accused are likely to be a danger to witnesses. Your Honor, look at the charge sheet. All witnesses are police officers. They are all police officers. I will not belabor the point. You have been told that the accused persons are a danger to national security. That submission has come to you from the bar. No evidence has been adduced to back it up. But nonetheless, Your Honor, there are certain presumptions that this court cannot lose sight of. And some of those presumptions are in this constitution. The security apparatus of this country follows a very clear structure created under the constitution. It is for the DPP to demonstrate why he believes that these accused persons have the machinery or capacity to undermine why it has not been demonstrated to you why these accused persons or how these accused persons will undermine the entire fabric or structure of that apparatus as created and contemplated under the Constitution. In the interests of time, Your Honor, I'm pleading with you as demonstrated by my learned friend Mr. Okach. These are Kenyans. Unless and until they are convicted of the offenses for which they have been charged, their constitutional rights under the Bill of Rights, and particularly the presumption of innocence, persists and are not suspended by the mere fact that they are now seated on that dock. Grant them reasonable bail terms. As your learned brother, Justice Mugambi, intimated, they cannot be incarcerated because certain individuals have broken the law out there. For those reasons, Your Honor, we pray that you disallow the application and allow these accused persons to reasonable bail and bond terms.
And on behalf of other accused persons, I'll take strictly 5 minutes. I'll not mention any law. My good friends have mentioned the Constitution. I'll only bring the context that brings them here.
Just 1 minute. Yes, Mr. Man.
Thank you. On the very first one, I'll base all my arguments on Article 27 of the Constitution. Non-discrimination. With the following 5 points. All the 7 accused people come from one political party called ODM. Secondly, Your Honor, they are members of Azimio. Third, they are all politicians. Fourth, they all come from the Luo ethnic community. Fifth, Your Honor, this is a proper ethnic political profiling.
Your Honor, with all due respect.
I said 5 minutes, I've only 2 minutes. Your Honor, this affidavit has no date, that's the second line, when it was sworn. This affidavit is as old as 2017. It is the same affidavit that was used to arrest the ruling class now. From 2017 to 2022, it's the same affidavit. And all those that were charged based on this affidavit, their charges were withdrawn. The court should take judicial notice that the same police officers who saw this affidavit came to court and said they were forced.
Your Honor, objection to that line with respect.
That is judicial notice of it.
The officer that deponed to this affidavit is before court. I haven't seen him ask Mr. Omari to talk about on his behalf. We just pray that that last line be ignored.
You know, Your Honor, it is me who represents them when the DPP wants to charge them. I'll give you specifically to the officer who saw the affidavit of the Deputy President. When that affidavit was disowned, the officer came to court and said he signed the affidavit under duress. It's specific and it's on the court record.
So, our clarity is that for purposes of today, the IO that swore this affidavit is before court. He has not spoken to Mr. Omari. Mr. Omari might have done very well in other cases, but this affidavit has not been said to have been sworn under duress. That's the only clarification I'm making. For today,
You know, I'm giving Mr. Witt the perspective that come 2027, the same will be disowned that it was signed under duress. For now, it will not be disowned. So that the court, as it is, it looks at the whole political context. Lastly, Your Honor, on this affidavit, I want to bring to the attention of this court that it is only the judiciary that is going to protect Kenyans. A great responsibility is on this independent arm. political dwells outside should not be criminalized. And we urge this court to see far and remove the political contests from criminal issues. This is a political matter before you. Deal with it the way it is. So, Your Honor, out of that 5 minutes I've finished, I allow the President of the Law Society of Kenya, before he removes me from the role of practicing, to talk.
Your Honor, with your very kind permission, I recognize the predicament. Yes, but Your Honor.
I know it's not normal to.
That tells you what is happening, Your Honor, in this court.
Just give you a few minutes, I sign this.
Okay.
I have so much to do.
Your Honor, that's in order. We'll give you a few minutes. You'll let me know.
Yes, Mr.
Your Honor, allow me to make very, very brief remarks on behalf of all the accused persons.
Are you comfortable submitting a slide?
Yes, Your Honor, because I do not intend to take very long.
Okay.
Probably 5 minutes at most. My colleagues have already submitted on the law and what is before you. And Your Honor, I want to begin by saying I do not envy the position you find yourself. And neither do I envy the position that the prosecution finds itself. Your Honor, what you are being asked to do by the prosecution is to employ unconstitutional means to achieve a constitutional objective. You know, the whole purpose of Article 49 and Article 50 of the Constitution is to uphold the dignity of the human person and also to uphold the dignity of this court. So you're right, with my humble submission that should you allow this application, in the manner in which it has been presented, and in light of the manner in which all the accused persons were arrested and treated, then, Your Honor, you will undermine the dignity of this court. Your Honor, this court has a public duty to not only uphold the authority of the Constitution, but to also give confidence to the Kenyan people that in the Republic of Kenya, the Constitution reigns supreme. So, Your Honor, in as much as I said that I may not envy the position you find yourself in, I think that what is before you is a very simple duty. And that is to send a message to the police, to the prosecution, and to the country at large.
Do you mind if I interrupt you again?
I am entirely in your hands.
Just another 2 minutes and be there.
Thank you.
Yes.
Yes, Your Honor, I was saying that you have a very simple duty. Because courts do speak through their pronouncements. And so therefore, Your Honor, I submit that your duty is to send a message to the prosecution, to the police, and to the country at large. That these courts intend to remain as courts of law any infractions on the Constitution will not find refuge in this court. My Lord, I say this because we are witnessing a dangerous trend of suspension of the Constitution and unless these courts speak, there will be no one left to speak for them. Your Honor, I kindly beseech the court to release all the accused persons with a bond of not less than 5,000, not more than 5,000. So that they can go home, reunite with their families. Because these proceedings are tainted with malafide, constitutional impropriety, and Your Honor, it is extremely, extremely regrettable and shameful that we have to waste precious judicial time conducting this manner of proceeding. I therefore join hands with all my colleagues and beseech this court in the shortest time possible, Your Honor, to dismiss the application that has been filed before you, and to release and to affirm to these accused persons that their rights under the Constitution will always be protected and affirmed by this court. Your Honor, I thank you for giving me the leeway to address you tonight. I am not used to this. It's Danson Omari who is introducing me to this. But I do understand that these are extraordinary times. Yes. And so they do call for extraordinary measures. And Your Honor, I thank you. Your Honor, if it is not asking too much, we know it has gotten into night time. But if it is possible, Your Honor, we would be happy to have your decision now. But if it is not possible, because we understand and we have seen that you've even had to stop proceedings so that you can undertake other matters, we would be more than happy to have your decision early tomorrow morning. Your Honor, I'm just being reminded that it would be important that they be remanded in a police station. Kileleshwa police station. Your Honor, I'm also being informed, and this is just for purposes of saving on time, I'm also being informed that the first accused is unwell and may require medication. To that effect, Your Honor, if you are unable to render your decision now, we would kindly beseech you that you make an order that he be taken to Nairobi Hospital for treatment, and that while at the police station, their right to counsel, to their advocates to see their clients, and the members of their family should not be curtailed. Your Honor, I thank you for that indictment.
Mr. Lim, I made you rush, and then I let the tap run for the defense. I'm not sure I should limit you again. I can let you proceed until you finish. But just an indication, how long will you take?
You know, because of the abundance of kindness, we have agreed that our learned colleague, Mr. Witi, is going to respond. And he had indicated earlier 7 minutes. I think we got additional 3 minutes of the submissions, including that have been made by a president. So we mind getting 10 minutes to respond.
Okay. Thank you, Your Honor. I will undertake to do under 10 so that I don't keep my seniors here, including my president, who today seems to have forgotten the prosecution are also his members. Okay. Having said so, Your Honor, we have listened carefully to submissions from our learned colleagues for the defense, and we understand where they come from. However, seated where I was sitting, 98, sorry, Your Honor. I am reminded that I should go slower than my usual speech. Your Honor, I was indicating to court that with the benefit of my mathematics prowess, 98% of the submissions before you today has been on alleged, and the word alleged is chosen deliberately, alleged violation of fundamental rights and freedoms. Because that is a jurisdictional issue, my submissions will start from that point. And our invitation to this court is that when you retire, to determine the only question before you today, which is whether the respondents should be released on bail pending hearing and determination of the charges before you. That this court should be minded that whenever a court does not have jurisdiction, it must not make any more step.
Yes, ma'am.
And that rule applies also to independent issues before you. And one such issue is whether or not this honorable court can entertain, hear, and or determine questions of alleged violation of rights and fundamental freedoms. Your Honor, the jurisdiction of the magistracy, the court to which Your Honor presides, is defined and prescribed by Section 8 of the Magistrates Court Act 2015. Section 8 is your jurisdiction to the extent that you can hear and determine alleged violations of human rights. And that section says that you can only hear questions of alleged violations of Articles 25A and B. Articles 25A and B. And that means the alleged violation of the right to legal representation, the alleged violation of the right to food, the alleged violation of the right to discrimination, right against discrimination, which was raised by Malena Senior Mr. Omari under Article 27. Sorry, Your Honor. I mentioned the right to food, right to freedom against discrimination under Article 27. All those fall out of your jurisdiction. And you cannot hear. In fact, in normal expectation, it would have been that the court would have stopped submissions on those points. You cannot hear and you cannot make determination around them. This is not to say that the ODPP, whose jurisdiction I'm going to mention second, denies or accepts that there were such violations. But we are saying that the forum for that determination, the forum for such a hearing is outside your mandate, and they cannot be the basis of your consideration. For the avoidance of doubt, the jurisdiction to hear and determine questions of alleged violation of rights and fundamental freedoms belongs to the High Court of Kenya under Article 165(3) of the Constitution of Kenya. (165(3) of the Constitution of Kenya, 2010. Related thereto is the jurisdiction to hear and determine any question as to whether any law any question as to whether any law or provision thereof is in violation of the Constitution. My learned colleague, Mr. Okach, tells you that Section 77(1) of the Penal Code was used by the used against the Mau Mau. It is in his view that it is an outdated law. We may agree, probably. However, it still forms part of the Penal Code, Cap 63 laws of Kenya. And more importantly, you have no jurisdiction to determine the constitutionality of Section 77(1) or any section of the Penal Code. And the court must down its tools on that aspect. That aspect cannot form the basis of your determination on bond. However, Your Honor, for completeness, sorry. For completeness on the question of jurisdiction, if, and this is an if, even if this Honorable Court had the jurisdiction to hear questions of alleged violation of rights outside Article 25A and B, and therefore could find or make a finding that there indeed was a violation of the rights of any of the respondents. Even if you could find that there indeed was a violation. Your Honor, I stress again that the prosecution is not saying there was or there wasn't, but even if you could make that determination, the Court of Appeal in Kenya, in the case of Julius Kamau Mbogwa, sorry.
You are very fast.
I'm sorry. I was born a quick speaker. I am struggling to go slower than I'm trying.
Yes.
The Court of Appeal in the case of Julius Kamau Mbogwa versus Republic, Julius Kamau Mbogwa versus Republic, Criminal Appeal number 50 of 2008, number 50 of 2008, this decision is equally reported on the Kenya Law Reports 2010. And as correctly noted by learned counsel Mr. Awele, that a violation of fundamental rights does not go into the root of a charge. We are again not saying there wasn't or there was. This court has no such jurisdiction. But even if that finding could be made, that violation, which can only be heard by the High Court, cannot go into the root of the charges before you, but is compensatable in damages.
A small point of objection. Nobody raised the question of jurisdiction and determination of constitutionality of sections. Council is dealing on an abstract matter. My two councils said here they shall follow that elsewhere. So we have not said this court has no jurisdiction. And we have not said that this court should declare the charge sheet defective or unconstitutional. That is the whole issue we are raising. So my good friend JV is delving into matters that were not raised by any of the defense counsels.
Yeah, just to help the court contextualize, when my learned senior Mr. Omari rose the first thing he told you is that he was going to give you a context and not the law. However, as he started, the first thing he told you is there is a fundamental issue of Article 27. That could have been in record. So what I'm basically saying
If I bring him clear, Article 49 that defines provisions for compelling reasons
let me deal with the question.
I was only finishing that to bring to perspective that the courts here, magistrates, look at Article 49.
And they apply it.
Yes.
They apply it,
yes,
but they cannot interpret it. So what we are trying to say is that, Your Honor, we are not asking for constitutional interpretations from you, or a finding that is based, or a constitutional finding. All we are saying, apply those ones as the law allows.
Thank you, Your Honor. That admission works for me. I have actually finished my submissions on that. I remind this court, it did not have to come from the defense for me to raise a question of jurisdiction. We are just reminding you that all the articles of the Constitution that were raised cannot be heard or determined by this court, and we will wait to address them before the High Court. I am done with that question. And, Your Honor, we plead with the court to take down that admission by counsel. They admit you are not the right forum to handle issues of constitutional violation. Secondly, I'll now come to the question of the role of the Office of the Director of Public Prosecutions. We have been accused for coming with unclean hands before you. Learned Counsel Ms. Bashir raises a contractual maxim, not applicable to criminal law, that anybody who comes to equity must come with clean hands. Even, sorry, anyone who comes to equity must come with clean hands. Even if the maxim were applicable, the obligation to prove that our hands are dirty was on Ms. Bashir. She has failed to prove that our hands are dirty. In fact, according to her, we should have been the one to prove that we have clean hands. That's against the rules of evidence. However, Your Honor, this is very critical considering the context of this case. The Office of the Director of Public Prosecutions, as established under Article 157 of the Constitution, has a role that is circumscribed. That role is clearly delineated. I will tell the court one thing that role does not include. It does not include supervisory powers over investigative agencies. Put differently, the Office of the Director of Public Prosecutions is not an appendage, neither of the National Police Service, nor of any other agency in the Republic of Kenya. Why do we say this? Sorry, Your Honor. Questions have been raised as to the right to liberty, the arrest of the respondents. At what point do you trigger the powers of the Office of the Director of Public Prosecutions? The powers of the DPP in exercising the mandate under Article 157(6) of the Constitution only triggered when an investigative agency has forwarded an inquiry or investigative file. The investigative file, the subject of this matter, was forwarded to the office today, and in record time, around 4 hours, the decision to charge, which in ordinary cases is made within about 14 days. In 4 hours, we had made the decision to charge, and we are before you.
You know, still, to help of counsel, I know the office of the DPP is vacant, and they might be shortlisted to contest for that position. Let him look at Article 157(4). If he will be confirmed as the next ODPP, he has the powers to direct the police. If he is admitting here that they do not have that power, then we have a big problem.
Your counsel is deliberately misquoting me.
Well, I
think to his advantage. The powers under Article 157(4) of the Constitution is given, in fact, it's the only power, the rest are mandates. The power of the DPP under Article 157(4) is to direct the Inspector General of Police to carry out investigations into alleged criminal activities. That cannot amount to supervision. In fact, to confirm that, you read Article 245(4) of the Constitution, which... Sorry, Your Honor. The law in me is...
Be careful, you might be sitting up there. Be careful.
So Your Honor, the supervision of the National Police Service is elsewhere, not with the ODPP. And like I've assured, I think this is in an assuring manner. We are not an appendage, and we are not a conveyor belt of charges. For us to come before you today, as already indicated, a decision to charge was made in accordance with the Constitution. The Office of the Director of Public Prosecutions Act number 2 of 2013. The ODPP decision to charge guidelines, on which the only test required of the Director of Public Prosecutions, or those of us exercising delegated authority, is whether or not there is evidence with a realistic prospect of a conviction. We may have been wrong in making our decision all right, but that discrimination will be made by the trial court. And that's why we have presented charges before you. We shall be expected to bring evidence.
Your Honor, if I may, and we do not want to interject our colleagues. With the kind permission, Your Honor, and just to save the court's time, and my colleague comes from my region, so we want to speak a lot, but there is no question about their power or the decision to charge. We do not challenge that. That is theirs, absolutely theirs. The question that is before you is that affidavit that denies them bond. They've already taken plea. We are okay with that. We'll deal with that. But the issues that we believe the court is interested in is the issue of whether there are compelling reasons, and he's avoiding that because there is no compelling reason.
Your Honor, I have that as my next issue. The court was here when a lot of arguments were made on why the office of the DPP has perpetuated an illegality, has violated the Constitution. We have a right to respond to that. That's actually why we're representing the ODPP here. That accusations were made against us. So just like we were very patient with the council, let them be very patient with us. It is very important to us, just like it is important to their client's case. So I plead with this court to allow me to respond to all the issues that they raised. And I'm almost done.
The next point.
Our next point is on the question of Article 49, on whether or not there exist compelling reasons. And Your Honor, we started with the question of jurisdiction. To guide this court with the humility, that is the only question that arises for your determination. Not the 98% of the submissions from the defense. Your Honor, first of all is the technical question about whether or not the affidavit is dated. It is not. However, a look at page 2 of the application makes reference to the deponent of the affidavit. Page 2 of the application. It identifies the deponent of the affidavit, and the affidavit speaks to the grounds in support of the application on the same page, page 2. Those grounds are 1 to 4 on the face of the second page. And finally, on that page 2, the application is dated. We therefore invite you to invoke Article 159 because the affidavit is stamped duly and it is signed. Invoke Article 159(2) and find it proper. For the avoidance of doubt, no application was made to you to strike it out. To the substance, when you retire, Your Honor, you are going to ask just one question. And that's probably what should have come from the defense, and we should have responded to in rejoinder. Whether or not the prosecution has established any compelling reasons to deny any of the respondents' faith. I reiterate the submissions of my learned senior on the contents of the application and the affidavit. Only to further refer this Honorable Court to clause 4.9 of the Judiciary Bail and Bond Policy Guidelines. Clause 4.9. And more specifically, 4.9c on character and antecedents, 4.9e on possible interference with investigations, and 4.9g on possible interference with witnesses. Those grounds are again on the face of page 2. Just before we go to page 2, the prayers on the application, and then on page 2 we say the grounds number 2, number 3, and number 4. Likelihood of interference with witnesses at ground number 3. Likelihood of interference with ongoing investigations, and finally the possibility of committing similar offenses, which goes to antecedents. Where do we get the facts? My learned senior, Mr. Awele, asks the question, whose reasonable belief? The belief is of one Corporal Geoffrey Mwangi. He identifies that belief in the affidavit, as should be done. What is the source of the belief?
Your Honor,
identifies.
with your kind permission. Your Honor, this is usually not my ordinary playground, and Mr. Whitty knows it. But I believe the rules still apply. He is supposed to be limited to questions of law in his rejoinder.
Yes.
And I think it is unfair for the accused people for him to start raising or making allusions, factual allusions, that we will not have an opportunity to respond.
On that basis, because I was silent, awaiting for the opportunity to raise that issue. And Mr. JV, learned counsel for the DPP, when addressing the question of the pre-arraignment detention, he did not direct you to look at the charge sheet on the date of the arrest, which is the 18th, and the date of presentation to court, which is 20th. I thought it was important for me to point out.
Yeah, maybe
no explanation has been
that last.
And no explanation has been offered. They never disclosed, and this is their charge sheet, unless they are denying it.
That's okay. Ivana will address that last. I was concluding on the issue of whether or not there is compelling reasons. We invite you to look at sorry, Your Honor. Sorry.
The issue that Mr. Owele is raised.
Owele.
Yes.
Is very critical.
It is the reason that I have said I'm concluding on that issue, so that I don't go on the issues of facts. I think that was guidance. I am very well guided. And in conclusion, we invite you that when you retire and look at the matters of fact on the affidavit, vis-a-vis the prayers in the application, you find that indeed there has been established compelling reasons to deny it. There are two questions of law that are left, which I conclude with. Edwin Shisanya Amboso versus Republic is a decision of the Honorable High Court, Justice Mugambi, that you've been referred to. We have agreed, and it makes sense, that there is a distinction between the orders granted in Edwin Sishanya, which rejected an invitation to declare assemblies unconstitutional or to issue conservatory orders to that effect. The charges before you are in respect of a criminal offense defined under section 77(1) of the Penal Code. We admit and agree with the defense that there exists orders of the High Court upholding the right to assembly.
Thank you.
We, however, are saying that what we have brought before you is charges for alleged criminal offenses, which will be determined upon hearing. Finally, the question about the dates on the charge sheet, I would have referred to three provisions of the Criminal Procedure Code. One of them, section 89(5). There was no invitation from the defense or any allegation that there was any impropriety on the charge sheet. And there's no order of this court rejecting charges, which would have happened under Section 89(5). Number 2, Number 2, Section 382 of the Criminal Procedure Code provides for an allowance in error of dates and names, among many other errors, and so that will affect the validity of the charges. Number 3 is that this court has the powers to direct suo motu or upon application by the prosecution to amend charges. That is still available. And that power and right exists all the way until before the accused is placed on his defense. In conclusion, Your Honor, you have been invited to send a message. I'm only concerned about the message you're sending to the prosecution. We plead with you that we have not shown, or you've not been shown any fault on our part to send any message. But even if you should, your role in this matter is to determine under Article 49(1)(h) whether or not there are compelling reasons or not to release the accused persons on bail. If that is the manner you are going to show or send us a message, we welcome it. No, Your Honor, talk from it. I'm neither. There's the issue I've been reminded about place of detention. Should this court not be able to make a determination in the next few minutes? And I have been advised by the Deputy Director of Public Prosecutions, who I am pleased to be leading me today, that we are not objecting to the accused persons being held at a police station. However, she has advised me that the police officers will have a discussion with where to place them, which police station to place them.
Let me tell you one off record. The day they'll arrest you, they'll take you to Cancun. That is a honorable member of parliament. Let us treat our leaders with respect, away from the police.
Yes.
When I was dealing with the SSU matter, I'm only talking to him as a friend. This is off record, Your Honor. Off completely record. I'm advising him.
We can talk about this off record outside.
No, I'm only advising state officers.
Your Honor, again off record as he sees, he has applied to be my boss. Your Honor, we are done. I'm just reiterating that we have no objection to the accused persons being taken to a police station. And when you become my boss, we will still do this.
Thank you.
Your man under me will be very different.
Thank you, Your Honor, for your time.
Your Honor, very, very, very. I know it's completely out of order, but I couldn't fail but notice one thing which my learned good friend did mention. That ordinarily the decision to charge takes about 14 days. But they did it within a record 4 hours, which of course we commend, even though we have reason to worry about the speed at which they approved that charge. Secondly, some of the suspects who were in Uhuru were also driven here at extremely high speeds. So that means I'm just speaking to the urgency in resolving this matter and still renewing the plea that we made before you. Understanding, Your Honor, that really you've had a long day. And if we can get a decision from you before we depart from this court, we will be greatly, greatly indebted to the court. But in the event that then at the earliest, Your Honor, I just thought that a good gesture such as this of approving charges within 4 hours should be met with an equally good gesture of this matter being determined within the shortest time possible. So, Your Honor, but I leave it entirely up to you. I just wanted to point that, and I'm sorry because I know this is out of hand.
But you know, there's only one more aspect that I'll address you on, the question of the phone belonging to the first accused person. Yes, sir.
Not now, please. I start sharing another application.
We'll address you in the day when you come in the next 30 minutes to deliver the ruling.
If it were not because of the large number of people in the courtroom and the consequences of not hearing you to the end, we would not have gone up to this point. But I thought if I stopped midway, maybe, we reason differently. Some of us would have started making noise. So that's why I've decided to let us proceed up to this time. But it is extremely unusual, isn't it? It's extremely unusual. So I know you would have liked to have a decision right away. And I'm also asking what would be the effect of that decision, whichever way it goes. If Madam, you fail in your application, and it goes to in favor of the defense now, will they be able to have the benefit of that decision now? I think the answer is obvious.
Yes.
So that's why I'm asking to do it tomorrow. Now that we've had a long day and a short night. By the time we get to our homes, it will be past 10 p.m. So that means the earliest I can start writing the decision is tomorrow morning. Because even after we finish, I still have something to sign. Many documents still to sign. So let me put that in writing. We are still sitting, eh? I don't know why they are going that way. So tomorrow, what time do you prefer?
I don't know whether it's possible to have it at around 9. What time?
How about 2? 2. Because till tomorrow I have to start sitting at 9.
Okay. Your Honor, of course, we really appreciate and we know that this is purely your decision. But we really want to plead with the court in light of the circumstances of this matter. An earlier decision is one that we would really plead with the court. So if we can get a decision at around, we know that we are really pressing the court. We are pleading with the court for leniency on this matter, and just in light of the circumstances, the fact that, Your Honor, we are here at this hour speaks to the uniqueness of the matter that is before you. The earlier we can get that determination, the better for all of us. Some of these aspects, of course, I do not wish to repeat what has been said by the learned colleagues. But the earlier we can get a determination so that we know whether the suffering ends or it continues, it makes it easier for everyone to know how they manage their affairs.
Yes, I get your point. So I'll try and have the ruling ready by 9 a.m.
Well guided.
I realize I cannot carry the file home because you never know what might happen in the Yes, you can meet even a bad group, so it is safe to let it remain here. So the first accused will be escorted to hospital for medical attention. And then the accused persons will be remanded at police station. Which one did you say?
Relation.
Okay. Is that where they came from?
No, they came from Wanguru. Others came from Wanguru. Wanguru is very far. Can't go back. You might even find now there are no vehicles taking them there.
So the accused persons will be remanded at Kileleshwa police station until tomorrow. Yes, I think we have come to the end, and just for housekeeping, this is now a humble request. It is at night, and I know definitely each one of us will have to walk out. So I just request as you walk out, just try to do it as peacefully as you can. Because you know the accused persons will be here tomorrow, and interacting with them at this hour may delay your exit. They know you have to leave, regardless of your relationships. So that's that you just take your time and exit peacefully. You will find them here tomorrow at night.
On behalf of all my colleagues, we wish to take this opportunity to thank the court and the prosecution and the court assistants and the members of the press and the gallery for the magnanimous time you have given unto us and the time and the kindness you've extended to the defense. We are so much humbled and obliged. Thank you.
To both sides.
I do confirm on behalf of the prosecution that the decision was that of Solomon. So we are really elected and we appreciate it.
Thank you.
And also for our colleagues.
Thank you.
Thank you.
So enjoy your evening.
Thank you.
I don't want to leave you here. I'll ask that you leave ahead.
That's very unusual, Your Honor. You're always the first one to leave. Official oblige. Yes. Nimekuletea ndevu bwana. I think you are the one who is you are the one who has the contact with the police.
MTV, let us
Republic versus DKN. This is it's an HCC reported case at Embu number A007 of 2021.
And the gist of this particular authority that we are relying on, the prosecution is supposed to lay a basis and provide a compelling reasons that would require bail bond to be denied to the accused persons. The nature of our application and the ground that we are relying on is that there is a likelihood that the accused persons, Your Honor, will continue to commit this particular offenses, this particular offense that has been read upon them. Your Honor, I do not need to believe that the first accused person, Your Honor, is an honorable member of parliament, and one of the places where continuous demonstrations that have turned and have led to destruction of property, obstruction of ordinary course of business going on, is Jacaranda. Your Honor, the other respondents, Your Honor, the other core accused persons, Your Honor, are individuals, Your Honor, whom have previously, especially for the second accused person, been charged with offenses that are related to coordinating unlawful recently taking place, which have led to destruction of property. And therefore, what the prosecution is praying for this court is that the compelling reason here is that even as we talk, or again as we submit before this court, there are certain acts of destructions that are ongoing.
Your Honor, I hate to interrupt my very good friend Mr. Riungu, but you have limited time and Mr. Riungu is actually giving evidence which is nowhere in the affidavit. And I know he knows that. I've tried to sit down, but my seat is becoming hot. I think let him just restrict.
Here I've had my learned colleague. And it is the hotness that we are stating that it is a compelling reason, Your Honor, that the court should concede. Second, Your Honor, the other, because of the limited time I have, the other authority that the prosecution wishes to rely on is the authority reported between Lydia Chelagat Kipyetich versus the Republic. Criminal case number A031 of 2021.
Criminal case number
031 of 2021. Delivered by Justice W. Korir at the High Court in Calvation. You know, also in this particular authority, it is a submission that, again, one of the compelling reasons that we have submitted through our affidavit, and which is cited on the second page, is that, again, where the accused persons are likely to commit further offenses, and secondly, where the accused persons, Your Honor, are likely to obstruct the cause of justice, Your Honor. Your Honor, under Article 24 of the Constitution, the right to deny Your Honor, under Article 24, the right to liberty is one of the rights that the court can curtail and limit, since it's not one of the rights that have been provided for under Article 25. And therefore, Your Honor, due to the constraints of the time that we have, we are praying that when you retire, that you look at the principles that the court highlighted in these two authorities to grant the prayers that we have sought for and prayed for. Very good.
the other authority. Yes, Mr.
I'll just have a little address, then I'll invite my learned friends to address you on some few aspects. I will address you on the aspect of the pre-arraignment detention in respect of the first accused person, to which the prosecution is guilty of, and further guilty of the duty of non-disclosure. The first accused person was arrested on the 18th at 0900 hours, that is 9 p.m. at JKIA when he was enrolled from Mombasa. 18th of July at 9 p.m. or thereabouts. He was then taken to, driven all the way to Kirinyaga County and detained at a police station called Wanguru Police Station. While there, Your Honor, he was denied his rights to make any contact to either his family members or his advocates. He spent the whole day there yesterday. Never ever even informed of the reason for the arrest. I am addressing a violation of Article 49 as I address you. He was denied right to access to counsel. And most fundamentally, he was denied the right to be produced before a court of law within 24 hours. This is a time at around 5 o'clock that 5 o'clock on the 20th of July that the accused person has been able to see a judicial officer or to appear before a judicial officer. There is no explanation that has been adduced why all that transgression had to take place. And it's always the duty of a trial court it's always the duty of the trial court to inquire on that particular aspect. As and when the same is brought to the attention of the court. Pre-arraignment detentions were outlawed, and Article 51 speaks to that fact. And the case in the court, the High Court in the case of Musa Bwagwa versus Mwanasi and 9 others, for the Chief of Kenya Defense Force, EKLR.
The case of
Musa Mwabwaga, that is MBWAGWA Mwanasi and 9 others, versus the Chief of the Kenya Defense Force and others, 2021 EKLR. That aspect of the arraignment detention was addressed. And the High Court said it was unconstitutional. And therefore, a charge that is premised on a violation of the Constitution, the court ought to interrogate. The integrity of that charge and the propriety of that charge. Even in the affidavit that they have brought before you, they have not addressed that aspect. As I pen off, the court is called upon by Article 23, by Article 3, to defend this Constitution. Article 10 enjoins the court to uphold the Bill of Rights and the rule of law and a just society. Article 27 enjoins the courts to ensure, Article 27 enjoins the court to ensure that there is equal protection of the law, equal enjoyment of the law, and equal benefit, and outlaws any form of discrimination. We need an answer. Why was Honorable Babu Owino not brought before court within the prescribed period? Number 2, whether a charge that is premised, I'm penning off. Oh, sorry, Your Honor. The answer that we are seeking is why he was not brought before the court as decreed by Article 49, clause 2F. Number 2, whether a charge that is premised on a violation of the Constitution has legal propriety, and whether the same can be the premises for denial of bail or bond. Mr. Okat will address you.
Yes, Your Honor, I will start by indicating, Your Honor, that it is true that actually not only the first accused persons, but all the accused persons are being arraigned before you, Your Honor, outside the mandatory 24-hour limit. Your Honor, the 5th and 7th accused persons were arrested on Monday the 17th day of this month, 2023. So that we are just shy of the 5 working day period, with the 6th and 2nd accused persons being arrested on the 18th alongside the 1st accused person. Your Honor, we will not belabor this fact because we will pursue it at the High Court in terms of the violations, Your Honor. But that is important because it tells you a lot as to why we are even addressing you at this time, Your Honor. Your Honor, what has happened, and in a nutshell, there is a skit that has been written and Your Honor, the duty of the investigators and with a lot of respect to the battalion of prosecutors, senior prosecutors, is just to ensure that these accused persons fit that skit. Your Honor, there is no iota of evidence that has been placed before you. Either through their affidavit, Your Honor, or the oral arguments that suggest that there is any compelling reason, Your Honor. None whatsoever. Your Honor, if you look at what they have attempted to indicate as compelling reasons, Your Honor, and that is from paragraph 7 to paragraph 12. Your Honor, you will see there's a repeated use of the word reasonably believed. Reasonably believed. But you're not being told, Your Honor, reasonably believed by who? To sustain this particular very heavy averment. Who is this who is reasonably believing, and on what basis? You do not have that. Your Honor, in fact, maybe this may not go on record, but this is the first affidavit I've seen from, HSC Victor Juma Witi that has no annexure at all. The very first one, I've never seen. And that tells you there's nothing. Witi can never do such an affidavit. There's nothing.
You know, clarity of record. It's done by the investigating officer.
I check that. It is okay, Your Honor, but you read it for yourself, and I do agree it cannot do that. However, Your Honor, you will notice that even on the substance of the charge, Your Honor.
He has a similar.
Yes?
He has a similar name.
It is my learned, but he has clarified, so I leave that point. But Your Honor, if you look at even the charge itself, to show you how they have actually stretched to the point of breaking a back. That is what the prosecution has done. Your Honor, they are telling you in very good English that these events happened on the 7th and on the 18th day of July. 18th, 2 days.
On which days?
On the 7th day of July and the 18th day of July. That is on the particulars of the offense. And Your Honor, they are telling you further that these events happened at Kamukunji. Your Honor, they have, and this is common knowledge to them, they have admitted that Babu was, the first accused was arrested at JKIA. On the same 18th, at around 10, because he landed at 25 hours. So, Your Honor, the question is, do we have two Babu Owinos? Does he have a clone that was at Kamukunji that day? Your Honor, it's able for the court's eyes, the ticket that says clearly he was landing at 21:25. Your Honor, if you look at further to demonstrate the fact that there is no compelling evidence, and indeed, even the substance of the charge is something that the court ought to look at in admitting the accused persons to bond. Your Honor, I'll refer you to paragraph 7.
Yes,
Your Honor, they are telling you, and my learned friend Mr. Ringo has told you that there are people who have been rioting or who have been picketing, especially where the first accused person represents that constituency. So that is the compelling reason you are being told. Your Honor, there is a decision or a ruling by your brother, and that is the Honorable Justice Mogambi. Your Honor, that is in the case, if I may, in the case of Edwin Sishana Amboso versus LSK and 4 others. We have provided that to yourself and to the prosecution. That is HCC petition 255 of 2023. Edwin Sishana Amboso. Your Honor, it says in Order 2 and 3, and I want to wind up at that point, that it is the responsibility of persons who have announced and organized the said demonstrations to provide guidance and leadership to the participants. Your Honor, the first accused person is not even a principal in the Azimio coalition. He wishes he would have been, he's not. And there is no evidence that has been given that he organized any of these protests. Which in any case, Your Honor, remains legal. It remains legal because your brother declined to injunct the said expression under Article 37. Your Honor, Order 3 is also very important. It says acts of violence and destruction are personal, and the relevant authorities must deal with individuals. Acts of violence or destruction of property are personal crimes. So it cannot be a crime where vicarious liability, like the prosecution is trying to adduce. Your Honor, the charge that has been prepared, Your Honor, the history of this charge is very important, and I think this court will